Company agreed to transfer the industrial property rights of the invention to company T. So basically, they are transferring the ownership of the invention, which makes us this is an assignment. And according to the clause 2, article 138, any assignment of industrial property rights must be in writing. And Article 140 also specifies that the contract must include the full names and addresses of both Company A and Company T, the reason for the transfer price, and the rights and obligations of both parties. And finally, for the assignment to be legally effective, the contracts must be registered with the relevant industrial property authority as required by Clause 1, Article 148. So, in summary, for the transfer of the lawnmower invention from Company A to Company T to be valid, the contract must be in writing, contain all the required information, and be properly registered with the authority. So that's all for the issue number one. Let's move on to the issue number two. This part as whether Company A can transfer the invention even if Mr. A, the inventor, doesn't agree. So according to point P, clause 1, article 86 of the IB law, an organization has the right to register an invention if it provides the funds and resources for an employee to create it as part of a job assignments. And in this case, Mr. A is an employee of company A and developed the lawnmower invention as part of its work. So the invention was made, they has the right to find a patient. And in fact, they did so on February 10, 2020. And according to Clause 1, Article 121, the lawful owner of a patient is the organization to which the patient is granted. And since the patient was officially granted on December 5, 2021, so Company A is the legal owner of the invention. So this means that under point A, clause 1, Article 123, Company A can authorize others to use the invention either by granting a license or transferring the ownership. And so the February 9, 2022 agreement to transfer the rights to Company T, which we discussed in issue number one, is a valid assignment. So as for Mr. A, as the employee inventor, he has the moral rights under Clause 2, Article 122. That means that he has the right to be named as the inventor and to be acknowledged in publications. He also has the economic rights under the Clause 3, Article 122, which means that he can receive the remuneration according to the Article 135. However, these rights do not give him the power to prevent the transfer. He only has the moral and the economic rights, not the ownership. So even if Mr. A doesn't agree, the company aims to have the legal right to transfer the invention to Company T because it is the lawful owner and has the full authority to assign the industrial property rights under point A, clause 1, article 123 and clause 1, article 138. So in conclusion, for the assignment of the lawnmower invention from Company A to Company T to be legally valid, the contract must be in writing, include all the required elements, and be properly registered with the competent authority. And on top of that, the company aims to has the legal right to transfer the invention to Company T, even if Mr. A doesn't give his consent. So, how does the Thai law regulate the assignment of industrial property rights? So, let's start by looking at the formal requirements for a valid assignment contract under Thai law. Since because company A is the patient T of the lawnmower invention, so it has the full rights granted under the patient. And under Section 38 of the Patient Act, a patient T can either like grant a license or assign the patient to another person. And in this case, Company A agreed to transfer the invention to Company T. And because this transfer gives full ownership of the patient to the community, so it counts as an assignment, not just a license, which would only allow someone to use the invention. And according to paragraph 1, section 41, a patient assignment agreement must meet two formal requirements. It must be in writing and must be registered according to the procedures set out in the ministerial regulations. And ministerial regulations no. 25 provides the detailed steps. For example, clauses requires the assignee, which is the community, to submit an application in the prescribed form together with the assignment agreement to the Department of Intellectual Property or a provincial commercial office. And paragraph 2 and paragraph 3 of the clause 5 also allow the assignee to appoint a registered agent to submit the application on their behalf with specific rules for both residents and non-residents of Thailand. In short, for the assignment between the company A and company T to be valid and enforceable, the contract must be in writing and properly registered according to the procedures and ministerial regulations no. 25. And let's move on to issue number 2 under Thai law, which asks whether the company AIM can transfer the invention even if Middle A doesn't agree. So under paragraph 1, section 11 of the Patent Act, the right to apply for a patent for an invention made as part of an employment contract belongs to the employer, unless there's an agreement saying otherwise. And in this case, Middle A developed the lawnmower as part of his job at company AIM, and there's no indication that his employment contract says anything different. So the right to the patient belongs to company AIM, and they exercised this right by filing the patient application on February 10, 2020, and the patient was granted on December 5, 2021, and from that date, company AIMS has been the lawful patentee. And because company AIM is the patient owner, so it has full rights to assign the patient under section 38. That means the February 9, 2022 agreement to transfer the invention to company T is completely valid. And even though Middle A is the employee inventor, he doesn't own the patient, so his disagreement cannot like block the assignment. However, under Section 12 of the Patent Act, when an employer benefits from the assignments of an employee's invention, so the employee is entitled to additional remuneration beyond their regular salary. But this is like purely monetary and doesn't give Middle A any right to prevent the transfer. So in conclusion, company AIM can legally transfer the patient to company T without needing Middle A's consent. If the assignment produce like benefits, so Middle A's only remedy is to claim extra remuneration, which doesn't like affect the validity of the transfer. And for the assignment of the invention under Thai law, so the contract must be in writing and properly registered according to the procedures set out in the ministerial regulations. Even if Middle A doesn't agree, company AIM as the lawful patentee still have the right to transfer the invention to company T. So finally, let's compare between the Vietnamese law and Thai law regarding these questions. So when it comes to the formal requirements for an assignment of industrial property rights, both countries take a similar approach. In Vietnam, the assignments must be in writing and registered with the competent authority, and Article 140 also specifies the mandatory contents that must be included in the contract. In Thailand, the Section 41 of the Patent Act also requires assignment to be in writing and registered to be legally effective. So, while both systems they require a written and registered contract, so Vietnamese law gives a further step by specifying the detailed contents that the contract must include. As for Middle East disagreement, both Vietnamese and Thailand law reached the same outcome. Company aims to have the legal right to transfer the invention to company T. This is because company AIM is the lawful patent owner and holds the exclusive right to assign it. And Middle East, as the inventor, only has the moral and economic rights, and he cannot prevent the transfer. So that's all of our presentations. Thank you, Prof. Kung, and all of you guys for your attention.
Ok, rồi cái hình cuối đẹp ha. Thank you ha. Rồi xin còn nhóm nào nữa không các em?
Dạ, còn nhóm em nữa với lại có một thành viên như em nó bị out ra thầy cho nó vô lại nha thầy.
Rồi ok.
Hi everyone. We are the group five. Today we will present the topic enforcement and dispute resolution in comparative intellectual property law. Beginning with the task one, present the measures for protecting intellectual property rights, including civil, administrative, criminal, and indicate which measure is the most common for handling counterfeit and pirated goods in Vietnam. Firstly, civil measures are the most common means for enforcing IP rights. Firstly, civil measures in Vietnam are applied to address acts in IP infringement at the request of the IPR holder or organizations and individuals suffering damage caused by such acts, even when the infringing conduct has been or is being handled through administrative or criminal measures. The legal basis in IP law is Article 198 and to 102 to 205. Um, the court may also impose provisional measures such as seizure, sealing, or prohibiting the distribution and infringing goods under the Article 207. The measures requires the plaintiff to prove ownership of right, actual damage, and causal connection in IP dispute. For example, a representative of AC Cook Vietnam stated that it had filed a lawsuit with the Bình Dương People's Court against Asia Foods Corporation for infringing the Hảo Hảo mì tôm chua cay trademark. According to the petition, on January 26, AC Cook discovered that Asia Foods Hảo Hảo product had packaging confusingly similar to Hảo Hảo noodles. In this case, the owner of the Hảo Hảo brand could rely on several measures to request the court to order cessation of infringement, public correction, and compensation for damage. The limitations of several measures in Vietnam comparing with the United States is complex procedures, difficult damage assessment, time-consuming and costly, and rarely used in practice. Yeah, and in United States, several measures are the most common means for enforcing IP rights and rights holder may initiate lawsuits in federal courts seeking remedies such as injunctions, actual or statutory damage. For patents, the legal basis is Patent Act. For trademark, civil remedies are provided under the Lanham Act, and for copyright, civil actions are governed by the Copyright Act of 1976. Regarding trade secrets, the Defense Trade Secret Act (DTSA) of 2016 is the main legal framework enabling federal civil actions without requiring state-level procedures. This is a highly effective system, allowing right holders to enforce the rights vigorously without relying on intermediary administrative agencies. However, damage awards in the U.S. can be substantial. For example, two of the fashion industry's most recognizable names were off when Gucci sued Guess, alleging that the latter has violated several of Gucci's trademarks. Gucci has originally asked for $221 million in damage, but settled for $4.1 million. Secondly, administrative sanctions for IP infringement involve competent state authorities applying specific measures to address violations of copyright, industrial property rights, and plant variety rights committed by organizations or individuals whose conduct does not reach the threshold of criminal liability. This is the most widely used and prevalent enforcement measure in Vietnam due to its speed, low cost, and accessibility as prescribed under the Article 200 and 214 of the IP law. Acts of the IP infringement may be subject to monetary fine, confiscation, and counterfeit goods, destruction of infringing items, suspension of business operations, and public disclosure of the sanctioning decisions. For example, the head of the Vĩnh Phúc Market Surveillance Sub-Department issued that administrative sanctioning decision against business Household Nguyễn Anh Minh, located in Licensed Reseller Group, imposing a fine of 446 million Vietnam dong for trading counterfeit cosmetic goods and dealing the smuggled cosmetic goods, and applying a remedial measure requiring destruction of all infringing cosmetic value at 47 million Vietnam dong. Administrative measures play a central role in Vietnam's IP protection system reflecting the state's determination to combat infringement. And the thirdly is the criminal measures. The legal basics is on a penal code of Article 225, 226, and Article 192 to 195. This is the most severe sanction compared to civil and administrative measures. Especially, individuals may be subject to fine of up to 100 to 1 billion Vietnam dong or imprisonment to up to 3 years. Commercial legal entities may be fined up to 2 billion Vietnam dong or permanently suspended. The report on the implementation of the coordinated program on combating IP infringement for the years 2022 and the 2023 action plan indicate that in 2022, the economic police nationwide 5 criminal cases for 5 defendants for IP infringement and 5 cases for 5 defendants were prosecuted under the Article 226 of Penal Code. And question B is indicate which measure is the most common for handling counterfeit and pirated goods in Vietnam. In our opinion, administrative measures are the most widely used mechanisms for handling counterfeit and pirated goods in Vietnam for 4 reasons. Yeah, first one is expedited procedures. Because of no litigation is required and enforcement occurs directly through the competent authorities such as the Market Surveillance Authority, Custom, and the Economic Police. 2 is low cost. Rights holders are not required to pay court fees or attorney's fee, unlike civil litigation, and mediate effectiveness. Infringing goods may be seized or destroyed, and business operation can be suspended immediately. And broad applicability suitable for small and medium-scale infringement, which constitute the majority of IP violations in practice.
So the chat 2 is about the case scenarios where Mr. A entered a cinema in Vũng Tàu. After sitting for 5 minutes, A used his phone to live stream the content of the movie being shown and post on a Facebook page. When the cinema staff intervened, he argued that he did not save the video to his phone or sell it, which he claimed is a non-commercial purpose. But what he did is purely a news reporting activity to review the movie for his followers. So, the first question is that is the act considered an copyright infringement? It's just specifically which property rights of the copyright owner who is the film producer has he violated. So first we must understand what is the copyright infringement. Under the Article 4, Clause 1 and 2, we get to know that intellectual property rights are the rights of organization, individual to their intellectual property, including copyrights. So what copyright is the right that the said organization and individual to works to the works that they have created or owned. So the subject of said work are listed under Article 3, Clause 1 as literacy, artistic and scientific works. Objects of copyright related rights include performance, sound recording, video recordings, broadcasting programs, satellite signaling, etc. So the form of said uh, was deeper in Article 14, mentioning the protected copyright work varying from textbook presentations to computer programs and computation of data. So from all this, we would have a kind of foothold to understand what is copyright and intellectual property rights are all about. So backing into our question, what's Mr. A action of live streaming an act of copyright infringement based on the given facts? We can conclude that the movie is an artistic work fall under the category of cinematographic works prescribed in point E clause 14 or article point E clause 1 article 14 of the law on intellectual property right 2005. So the rightful owner, as mentioned, is the film producer, have all the right to authorize or approve people to make a derivative or copies of their movie. So using the Article 28 Clause 3, the act of live streaming the movie is an act of republishing a work, but that Mr. A have the authorization is a key problem, which we all know he didn't, given the fact that the staff have intervened. So, what is the harm right of the film producer? We can, basing on the Article 19 and 20 of the IPL law, we can conclude that Mr. A have violated a moral and economical rights of the film producer. First, the moral right. Mr. A act of live streaming violated clause 3 of Article 19, which is the owner or the copyright holder have the right to publish his or her works or authorize another person to do it. So, as mentioned earlier, Mr. A infringement of copyright was done by republishing the works without any authorization. It's a direct harm to this right of in Article 19. A more straightforward right that was harmed is the economic right, where the owner have all the right to reproduce, make a derivative, or to list the works as prescribed under the Article 20 Clause 1 of the IPL law, which Mr. A didn't have the authorization and did all that to and post it on a social media platform may effectively decrease the value of the movies, damaging the economical rights of the film producer. So that is the first question. Then, what can the film owner of the said movie do to protect his intellectual property right? So, To protect one's right from the harm, like mentioned in the case, the copyright holder can seek measure as prescribed in the Article 198 of the IPL law. First, we have some precaution measure, which can come down to technical and contracting term. So, for technical term, the copyright holder can use their resources to make some distinctive technical signs in their product, which could be watermarking, some tracing, or like changes, some sudden changes in audio data. Besides that, when publishing their works, they can they can request the contracting cinemas to provide additional staff training, putting some policy like no device, no electronic policy when coming to the cinema, and lastly is the update on a more advanced monitoring system, which can be AI integrated to prevent any activity of copyright infringement of their work. So secondly is the immediate approach when they found a violation right at the place. The first to approach up is required in the Article 198 is the requesting the violator to terminate their infringing act, to apologize and publicly rectifying and compensate for the damages. And the owner can also request the competent state agency to handle act of infringement in accordance to the intellectual property rights law. So with the artillery infringement, the act of live streaming done by Mr. A can be subject to Article 18 of the Decree 131 in 2013, which was supported by Decree 28 in 2017. So from the said degree, Mr. A violation can be fined to from 15 to 35 million Vietnam đồng, with the act of removal of the copies on all platforms done by Mr. A. So the last is the legal approach. Once there were violation, basing on the severity of the conduct or the result, it may come down of the live stream. The film producer can file a lawsuit via court or arbitration center to protect their lawful interests and rights. If they suffer damages caused by the infringement,